All right, up next, we have the ease of criminal justice in India. And the keynote speech is being given by Vivek Sood. Vivek Sood sir is one of the leading senior counsels based in Delhi with 3 decades of law practice, a prolific author, a frequent speaker on contemporary legal and constitutional issues on public platforms. As a senior counsel, Sood is well known for being engaged in complex legal briefs in diverse branches of law, including criminal, constitutional, and commercial laws. Apart from a very successful law practice, Vivek Sood strongly believes in contributing to the development of law and other socio-legal causes such as promoting DNA evidence, the human right to fair trial, and free speech. Thank you so much for joining us here today, sir. Can you please have a huge round of applause for Vivek, sir?
Good afternoon to all of you. And first of all, I'm grateful to the organizers of Vidhi, Utsav for inviting me on this platform. At the earlier session, I was here for the last about 15 minutes. It was a very interesting session, where you got the perspective of some very eminent women lawyers. And I have always believed that women lawyers need much more push and promotion, so that there are more women judges, senior counsels, etc. Now with that behind us, I'll speak on the ease of criminal justice in India. And I have identified 6 areas of law where we need reform so that there is ease of criminal justice in India. The first area that comes to my mind is the abuse of criminal law in India. Now, by abuse of criminal law, I mean that the false criminal cases that enter the criminal justice system. In my book, Chaff and Grain, I have identified 3 or 4 areas where the false cases that enter the criminal justice system is rampant. First of all, we have all seen, we have all read news reports. Many of us are lawyers out here, lawyers, judges, policy makers, NGOs. False cases of rape that are entering the justice systems today. Now, I'm not saying all cases are false. I mean, that's not the proposition. But this branch of law is being grossly abused, where so many kinds of disputes are converted into false cases of rape. That's one area. Another area is the misuse of POCSO, misuse of the law with respect to, sexual harassment of children. A lot of disputes are settled in the police station or the court by misusing POCSO. Another area where there is gross abuse of criminal law is the conversion of business and property disputes into false cases of cheating. Because, the mindset is that the civil justice system is very dilatory, it is very slow, it is very costly. So therefore, the criminal remedy is a shortcut to resolution of civil disputes. There is no court fee. You go to the police station, you convert a civil dispute into a criminal case, you call it cheating, you go to a good criminal lawyer, he'll convert a simple business disputes into a case of cheating, get an FIR registered, and the police will keep chasing the accused, and finally, with the pressure of the police, the pressure of being prosecuted, the pressure of being arrested, you get a settlement in your favor. It's a kind of a legal extortion that happens. Another area of law which is grossly misused is the false cases under the Scheduled Caste, Scheduled Tribes Act. I have seen in my career, I have seen so many, promotion-related disputes in government institutions being converted into false cases under the SC/ST Act. Or I have also seen, in a building contract where a colleague of mine, I will not name him, he happens to be the additional Solicitor General of India. His house was being constructed in Noida, and he had some dispute with the contractor. And that dispute was converted into a false case under the SC/ST Act. So this abuse of criminal law is a major problem that we have on our hands. Now I reiterate that I'm not saying all cases are false. There are genuine cases, there are truthful cases, but there is a gross rise in the number of these false cases. Now, how does ease of criminal justice come in? When these false cases are foisted, there is a lot of suffering, a lot of harassment to the accused. Many of those accused men and women, they are arrested, or they have to struggle for anticipatory bail, they have to struggle for regular bail if they are arrested. They have to go through with the Kafkian trial in the court that takes decades, and ultimately they are acquitted. The falsity is exposed. And that is where there is a full stop in the criminal justice system. That is the vanishing point of criminal justice in India. Now, you have the law of perjury, you have IPC offenses, where if you file a false case, you are liable to be prosecuted. But it is too much for the acquitted accused, or the accused who is discharged from the criminal court. It is too much for him to initiate a fresh prosecution against the complainant who filed a false case. The mindset is, I've had enough of the criminal justice system. Finally, I have been acquitted. Let me quietly go home from the back lane. I don't want more of criminal justice in my life. That's the attitude. Because there has been so much of persecution, so much of harassment, that the man has lost the stamina to fight another legal battle. Therefore, with my experience of over 3 decades as a criminal side counsel, I suggest that we need a reform in this area. Now, one of the reforms could be that when the court is passing a judgment of acquittal, or where the High Court is quashing the criminal proceedings on the ground that there is patent falsity in the allegations, the case was false, rather than the acquitted accused initiating prosecution, the court concerned should initiate the prosecution. This is where the ease of criminal justice comes in. It will act as a deterrent against false cases. Secondly, with my experience, I can say that 99.99% cases which are found to be false, there is no redressal. The complainant is not affected at all. because the accused has secured an acquittal, but it does not harm the complainant at all. So we need, in my view, we need a reform in this area where the court concerned must initiate that prosecution. That has to be brought into the law. Similarly, perjury by witnesses is a pandemic problem in the criminal justice system today. Supreme Court has said time and again that we hardly come across a witness in India whose testimony is free from falsity, exaggeration, embroidery, and embellishment. The courts have time and again said that almost every witness who comes into the witness box commits perjury. Now, very unlike in the system, in the UK or the US, where perjury is not tolerated at all. We've had cases where, noted authors like Jeffrey Archer, they committed perjury and they suffered jail terms in the UK and US. Perjury is rampant in India. And there is no remedy against perjury. No action is taken against perjury. So I will advocate the lawmakers and the policy makers to amend the law. When the accused is being acquitted, the court concerned, the trial court or the appellate court, must give a report. It should be mandatory for him to give a report or pass an order as to the demeanor of the witnesses, as to the perjury that has been committed by the witnesses. It has to come on record. It must come on record. Again, you can't leave it to the acquitted accused after a Kafkian trial to initiate prosecution against those witnesses who commit perjury. This will also enhance the credibility of the criminal justice system. This is also a part and parcel of ease of criminal justice in India. The criminal justice system in India is losing credibility because of false cases, because of rampant perjury that happens. The third aspect of ease of criminal justice is bail. Now, there are some initiatives, some very positive initiatives have been taken by the Government of India insofar as bail jurisprudence is concerned. Recently, I was reading this scheme called Support to Poor Prisoners Scheme. Many poor prisoners languish in jail in spite of having been granted bail by the court because they don't have a surety. They don't have the financial support. Or they languish in jail because they can't pay a fine of 5,000, 10,000, 20,000, 30,000. They can't pay that fine. So they languish in jail. You have something called the in default punishment. If you don't pay the fine, you will remain in jail for a further period of 3 months or 6 months. The poor people don't have that 10, 20, 30, 40,000 rupees to pay. Instead, they suffer jail term. Now, government has come out with an initiative where if within 7 days of grant of bail, if the man is not out of custody, the superintendent of jail, the jail authorities will refer the matter to the DLSA, Delhi Legal Services Authority. And then you have the empowered committees, etc. And then NGOs, etc. So, the society, these organizations will come and help the accused come out on bail. It's a very good initiative. And poor prisoners who can't afford to pay the fine, there's government support. Government supports them with the money to pay the fine and come out of jail. Now, we need to add a few features to this kind of a scheme. One of the features is, in many cases I have seen, bail is not granted to the accused, even in minor offenses. Because of maybe the ideology of the judge. You have judges with a very strong ideology, where you have judges, my colleague friends from the bar will support me on this. There are judges who don't grant bail at all. We call them bail deniers. Even in minor offenses, they will not grant bail. They will say, Vakil Sahab, aap High Court jaiye. I will not grant bail to you. Now, in my view, you should have empowered committees like the one you have already to support poor prisoners, where the government should support the release of bail of some prisoners in minor offences. Of course, the discretion of the court must be retained so that there is no abuse of this kind of release on bail. Then you have some states have come out with some very creative policies. For example, I was reading Telangana. They have come out with this policy that convicts and accused who are above 70 years of age, they will be granted some kind of a relief in terms of bail, etc. So, relief to women prisoners, relief to old prisoners, relief to infirm prisoners who are very unwell, languishing in jail. So this will also go a long way to ease criminal justice in India. Another feature that I find, and our Chief Justice of India, Justice Chandrachud, recently he remarked that why is the district level judiciary in India, why are they reluctant in matters of bail? Now, in my view, the only reform, the only answer to this problem is judges at the district level ought to be trained on principles with respect to Article 21, the fundamental right to life and liberty, the principle of jail not bail, bail not jail. You must have some accountability structure. There is no accountability structure in place. You apply for bail before the magistrate's court or the sessions court, he denies the bail. Your bail application is rejected. Now, there is no audit. There is no accountability structure by the High Court. The remedy available to you is you move the High Court. How many of the poor accused men and women can afford to move the High Court or the Supreme Court? Then the High Court and the Supreme Court are overburdened as courts. What takes a few days in the district court takes months or even years in the High Court and the Supreme Court. So you need more training to the district level judges. You need an accountability structure to make these judges accountable to the system. Then you have judges, and this has been remarked by the Supreme Court in Satinder Antil's case recently, Justice Kaul and Justice Sundaresh. They have observed that many judges at the district level, they deny bail so as to punish the accused, because they know at the end of the trial, the man will be acquitted. Witnesses will not support the case of the prosecution. So they know that this case will end in an acquittal. So they have this mindset, let me keep the man in jail for as long as possible. Now these are the practices that have been happening in our country, and we need to reform. And I repeatedly have said that criminal justice can be best administered by the district level judiciary, not by the High Courts and the Supreme Court only. That's where the accused is first produced after being arrested, before the magistrate's court. Then another significant feature of ease of criminal justice is the misuse of the power of arrest in our criminal justice system. Way back in 1991-92, we have the judgment of Justice Venkatachalaya, Joginder Kumar's case. 2016, Arnesh Kumar, where the Supreme Court has laid down the principle repeatedly, arrest must be governed by necessity. It should not be a routine. But somehow these judgments, with my experience, they don't percolate into the police station. They don't reach the police station level. Supreme Court keeps laying down propositions after propositions, but they don't enter the propositions, don't enter the mindset of the police. You know, we still have a very colonial police system in our country. It has been said so by the Supreme Court in Arnesh Kumar, Joginder Kumar, that the Indian police system is highly colonial. Then I have also observed, as a criminal side counsel, that the legality of arrest gets lost in the maze of criminal justice in India. Now, what I mean is, when a man is arrested, the focus of lawyers and judges shifts to bail. The legality of the arrest is not adjudicated. Now, it must be adjudicated whether the arrest was legal or not, whether the arrest was governed by necessity or not. It has to be adjudicated. It never gets adjudicated. The whole focus has shifted to bail applications. And again, police officers violating the principles of arrest must be made accountable. The accountability is totally lacking. Now you have a few very good orders. For example, Justice Waziri, Delhi High Court, Allahabad High Court, in a few cases, they have actually sent those police officers to jail. Unless you have a system of deterrence against unlawful arrests, the system will not improve. You must have an accountability structure. A policeman wrongfully arresting the accused being released on bail is not the end of it. It is not a full stop. The police officer must be held accountable for wrongful arrests. This will also go a long way in easing criminal justice in India. Another aspect, I've written about this in Chaff and Grain also. We in India follow the principle of chaff and grain, meaning thereby it is the duty of the judge, when he is examining the testimonies of witnesses, he has to separate the chaff and grain, the falsehood from the truth, and arrive at a judgment. Unlike in the US system. In the US system, if a witness is found to have made a false statement on any one material aspect, the whole testimony is liable to be rejected. Not so in India. Because all witnesses are committing perjury. Wholesale perjury is happening. So every accused will go scot-free if we apply the US principle. Now, a principle of chaff and grain has to be applied with utmost care and caution. Because, I have seen 2 minutes. 2 minutes, please. Even I have a flight to catch, 2 minutes. Yeah. So it has to be applied with a lot of caution and sensitivity. Because I have seen a lot of innocents being convicted because of the misapplication of the principle of chaff and grain. Separating chaff and grain is almost like a divine function. Very difficult. Now the last part, protection of free speech and criminalization of hate speech in the age of social media. We need reforms in this area. Defamation on social media is not the defamation that we had in the earlier times, where defamation was restricted to pamphlets or newspapers or magazines. Social media is very different. A lot of anonymity is there on social media. So as a victim, I may not be able to track who's done this, who's put the defamatory material against me. Then multiple acts of defamation happen on social media. It can be repeatedly done again and again on social media. Defamation on social media sticks forever. It is there forever. Even after 1,000 years, Google search will reveal it. So with these kinds of features of defamation in the age of social media, we need to reform the legal system. Then, in my view, social media abuse needs to be defined properly in law. There is no definition of social media abuse. That's why, when you read these newspaper stories, West Bengal, somebody got arrested, this happened, that happened, he made a caricature of the chief minister, was arrested. When you look at the provisions, those provisions are not applicable. But the man is arrested. So the lawmakers must define social media abuse appropriately. That definition is not there in our law. So these are the 6 or 7 areas which will ease criminal justice system, criminal justice in India. Thank you very much for being patient. Thank you.
यहीं पे स्टेज पे या नो जस्ट स्टेज पर जस्ट Thank you so much, sir, for that speech. And I think what I gather from that is, in a country like India, I don't think it's either about acquittal or denial. I think sometimes it's the process in itself which is the punishment. Please present this memento to sir. Thank you, sir.